Good afternoon. My name is Daniel Martinez de la Vega. I'm an employment lawyer in San Francisco, California, and today I'm going to briefly talk about disparate treatment. And specifically, I'm going to talk about jury instruction 2500, disparate treatment, essential factual elements under Government Code section 12940A. And this can be found on courtinfo.ca.gov. These are jury instructions that are actually read to a jury by the judge after your case has finished and the jury is about to make their decision. This is what they would hear actually from the judge. And specifically, I want to read what the judge would read, and also I think a key case that makes it easy to understand what disparate treatment is. So the jury would hear that one, that the defendant was the employer, that the plaintiff, the employee, was an employee of the defendant, applied for a job or was an employee of the defendant, that the defendant, the employer, discharged or refused to hire or some other adverse employment action, and that the plaintiff, the employee, had a protected status, meaning that the person's race, gender, or age was a motivating reason for the discharge or the fire or the adverse employment action, and that the plaintiff, the employee, was harmed, and that this decision was a substantial factor in causing the damage or the harm to the plaintiff. And so that's briefly what would be read to a jury. And on page 1395 of jury instructions, there's a section that I want to read that makes it easy to understand what disparate treatment is. It says, conceptually, the theory of disparate treatment is most easily understood type of discrimination. The employer simply treats some people less favorably than others because of their race, color, religion, sex, or national origin. California, there's also sexual orientation. For example, if your employer uses that in a decision to fire or discharge, demote, that would be a protected status. These cases can be very technical and complex, so it's always important to contact an attorney soon after you believe that demotion or the adverse employment action happened, because there are a lot of statute of limitations that come into play, and you want to make sure that you don't lose your right to file your lawsuit because you waited too long or because too much time passed from the event or the adverse employment action.